Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the IBC, which is now reshaping the economic landscape of India. So let us discuss one landmark case today. So this is the case of Ebix Singapore Private Limited versus Committee of Creditors of Educomp Solutions Limited and others, decided on the 13th of September 2021 by the Honorable Supreme Court of India. Now, the Supreme Court, via its judgment dated 13th of September 2021 in Ebix Singapore Private Limited versus Committee of Creditors of Educomp Solutions Limited and others, has decided on the issue relating to the withdrawal of the resolution plan submitted by the resolution applicant for the revival of a corporate debtor after its approval by the Committee of Creditors in accordance with Section 30, subsection 4 of the IBC 2016. Let us see the factual background of the case. Now, the corporate debtor, which is Educomp Solutions Limited, filed an application under Section 10 of the IBC 2016 to initiate CIRP, on which an order was passed by the adjudicating authority on 30th of May 2017, initiating the CIRP. Now, the COC was constituted and the information memorandum was issued by the RP. The appellant submitted its resolution plan dated 27th of January 2018. The COC approved the resolution plan of the appellant and declared the appellant as the successful resolution applicant. An application for approval of resolution plan was filed. Now, during the pendency of approval of the resolution plan, the appellant filed an application for seeking withdrawal of the resolution plan. The adjudicating authority rejected the application. Now, Ebix Singapore Private Limited, which is the RA, sought to withdraw its resolution plan inter alia on the following grounds. One is inordinate delay in the approval of the resolution plan by the Honorable NCLT beyond the period of 6 months envisaged under the RFRP, and the pending and ongoing SFIO and CBI investigations into the management and affairs of Educomp. The Honorable NCLT allowed the withdrawal application filed by Ebix by order dated 20th of January 2019 and held that the resolution plan becomes binding only after it is approved by the adjudicating authority and on account of pending SFIO and CBI investigations corroborated with inordinate loss of time and unwilling cessare could not be expected to effectively implement the resolution plan. As a consequence of this order, the Honorable NCLT dismissed the plan approval application filed by the RP being infructuous. Now, an appeal was preferred by the COC of Educomp before the Honorable NCLAT against the NCLT's order, and the NCLAT reversed the NCLT's order, permitting withdrawal of the plan. The Honorable NCLAT held that the adjudicating authority, after approval of the resolution plan by the Committee of Creditors, had no jurisdiction to entertain or to permit the withdrawal application filed by the Ebix, which is resolution applicant. Thereafter, Ebix filed a civil appeal before the Honorable Supreme Court under Section 61 of the Code, assailing the NCLAT's judgment dated 29th of July 2020. Now, the civil appeal filed by the appellant was heard and decided, and the Honorable Supreme Court, by judgment dated 13th of September 2021, dismissed the appeal. The Honorable Supreme Court, while dismissing the appeal filed by the appellant, noted and considered all the pleas raised by the appellant as to why the resolution plan be allowed to be withdrawn. Now, what were the contentions by the appellant? Now, Ebix is not bound by the resolution plan until the same is approved by the adjudicating authority, as per Ebix. Events are subsequent to the submission of the plan, like inordinate delay in the approval of the application under Section 31 and pending investigations into the affairs of Educomp, called for withdrawal. The adjudicating authority is empowered under the Code to permit the withdrawal of a resolution plan prior to its approval under Section 31 of the Code. Now let us see the contentions by the respondents, which were the COC and the RP. Now, as per them, the resolution plan approved by the COC is a binding agreement inter se COC and SR, and non-implementation of resolution plans after approval from the adjudicating authority under Section 31 attracts prosecution under Section 74, subsection 3 of the Code. Permitting the withdrawal would push Educomp towards liquidation. Ebix contention that the 6 months time period under RFRP for approval also includes its approval by the AA is contrary to the Code, since the parties through an agreement cannot impose a restriction or a condition on the judicial authority. Further, the relevant clause of the RFRP, which states that the resolution plan will be binding on all stakeholders only after the approval of the adjudicating authority, does not militate the binding effect of the COC approved resolution plan, inter se COC and SRA, which is a concluded contract. Now, the delay in the resolution process is not attributable to the COC. Now, let us see what was the observations of the court. The Honorable Supreme Court rejected the argument of Ebix and observed that the 6 months time period under the RFRP relates to the validity of the resolution plan for the period of negotiation with the COC and not for a period after the resolution plan is submitted for the approval of the adjudicating authority. The court held that parties cannot indirectly impose a condition on a judicial authority to accept or reject its plan within a specified time period, failing which the CIRP process will inevitably come to an end. Even otherwise, the terms of the RFRP did not provide any timeline as regards to the approval of the plan by the AA. The court further noted that the validity of the resolution plan being 6 months was not mentioned as a condition precedent in Form H that was submitted by the RP along with the resolution plan to the AA, which evinces that the 6-month validity was only vis-a-vis acceptance by the COC. Further, the court observed that Ebix was responsible for conducting its own due diligence of Educomp and could not use that as a reason to revise or modify their approved resolution plan. Section 32A of the IBC grants immunity to the corporate debtor for offences committed prior to the commencement of CIRP. Therefore, RA need not be impacted with the ongoing investigations. Further, the court noted that no clause under the Ebix's own resolution plan provided them with the right to revise or withdraw their resolution plan after its approval by the COC, but before its confirmation by the AA. Further, Ebix was aware of all the proceedings before the NCLT, since the various applications were often listed along with the approval application in which Ebix continued to appear. Now, let us see the decision by the Honorable Court. The Honorable Court held that the residuary powers conferred on the adjudicating authority under Section 60, subsection 5C of the IBC cannot be exercised to create procedural remedies which have substantive outcomes on the process of insolvency. The existing framework only enables adjudicating authority to permit withdrawals from the CIRP under Section 12A of the IBC and Regulation 30A of the CIRP regulations, conferring jurisdiction on the NCLT to deal with withdrawals or modifications of the resolution plan at the behest of the successful resolution applicant once it has been submitted to the AA would create another tier of negotiations and trigger litigations which is not akin to the object of the IBC, thereby would risk delaying the insolvency process under the IBC. Had the legislature intended to recognize the concept of withdrawals or modifications to a resolution plan after it has been submitted to the adjudicating authority, it must have specifically provided. In the absence of provisions in this regard, such omission cannot be supplied by way of the judicial construction. So we conclude that the present judgment emphasizes that the framework under the IBC indicates the clarity of its purpose, that is, primacy of the interests of the creditors who are seeking to cut their losses through a CIRP. A submitted resolution plan is binding and irrevocable between the COC and the successful resolution applicant in terms of the provisions of the IBC and the CIRP regulations. This judgment underscores that the SRA cannot withdraw from an approved resolution plan without specific legal grounds under the IBC. It further clarifies limited grounds on which NCLT can reject a COC-approved resolution plan under Section 31, which is mainly non-compliance with Section 30, subsection 2 requirements. Further, the commercial wisdom of COC in approving a plan cannot be questioned by NCLT or SRA without legal basis. Further, it upholds the sanctity of CIRP timelines and the binding nature of SRA's resolution plan post-COC approval under the IBC framework. So, friends, we see that the Honorable Supreme Court has upheld the primacy of the interests of the Committee of Creditors and the sanctity of the process under the IBC. So, friends, I trust that you find this both engaging as well as enlightening. So, for further insights into the key judgments under the IBC, please like this video and subscribe to my YouTube channel. So, thank you for being with me here today. This is Deepika B. Prasad signing off. We'll catch you in the next case. Thank you.